Good morning, all. This return date hearing is in the matter of CFI 029-2025 and is being held by way of video conference before His Excellency Justice Roger Stewart, KC, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Watson, Farley and Williams. Lead counsel is Ms. Charlotte Bijlani. The defendants are represented by Hamdan al-Shamsi, lawyers and legal consultants. Lead counsel is Mr. Robert Whitehead. Thank you, Your Honor.
Thank you. Can we just see where we are? Perhaps Ms. Bijlani, you could just update me as to where you think we are.
Yes, of course, Your Honour. On Tuesday evening, we were directed by the court to try and agree a procedural timetable with the Respondents' Council. We had a call yesterday and could not agree matters. WFW then emailed counsel for the respondents with the directions that they would be seeking, and those directions are set out at the end of the note submitted on behalf of the applicants at 4 p.m. or just after 4 p.m. yesterday to the court. And so essentially, because the order has not been complied with, in particular the provision of information has not been complied with, and the applicants say without any good reason or explanation, the applicants take the view that Mr. Jummer, who's already filed a first affidavit, which I can take you to if you haven't seen it already, but essentially within that affidavit, he states that he requires at least 4 weeks to comply with the worldwide freezing order, specifically the provision of information directions.
I've seen that affidavit very well. What I haven't seen is your note at 4 p.m. yesterday, and I'm sure that's my fault.
I can take you to the note.
Well, don't worry. You filed a note with directions. Just before we go to that, Mr. Whitehead, can you just tell me where we are from your point of view?
Yes, Your Honour. Your Honour, you'll see from have you had the chance to review the respondent's note?
No, I was travelling yesterday, and it may be. I mean, I can't actually see the document in my emails, and it may be that I just haven't. I've overlooked it, but I haven't got your note. So perhaps you could just tell me where you think we are very briefly.
Of course, Your Honour. So look, Your Honour, our position is, again, based on our email yesterday and the note, that this cannot be an effective substantive return date hearing. As Ms. Bijlani's alluded to, the respondent was required to provide assets of $25,000 or more, including the value and location. However, there's various factors here. The respondent will require time to collate those documents.
Look, I think sorry to cut across you. I think the most effective way is this. You've obviously both filed notes. Can you please, both of you, send those notes to my DIFC email address now? And what we'll do is we'll just adjourn for 10 minutes. What I think I'll probably do is just turn my I was going to say turn my camera off, but turn my microphone off, and I'll read your notes, and then we'll reconvene again. If you can send those through immediately, I suggest we reconvene at 25 to the hour in 15 minutes time.
I'm sorry to interrupt, Your Honour. I just want to confirm that the registry's email attaching the notes was sent to you at 9:45 a.m.
9:45 this morning, right? Let me just have a look. I don't think I've got that for some reason.
All right,
hang on.
I'll go ahead.
No, sorry. Wait a second. Yes, I've got it now. Let me. Right, I've got those. Don't need to email them. We'll just adjourn for 15 minutes until 25 while I read those notes.
Very well. Thank you.
Thank you.
Apologies. I've now read the notes. If the parties are ready to resume the hearing, I am ready to resume the hearing.
I'm ready to resume, Your Honour.
Apologies, I just connected.
No need to apologise. I said it was going to be in 5 minutes' time. Let me just check that the court is ready for me to resume as well. Are
Yes, Your Honor.
you okay?
Thank you. Yes, thank you.
Very good. So, as I understand it, the position is as follows. Ms. Pidgelani, you say that there has been non-compliance and that there ought to be a further affidavit filed. Mr. Whitehead, you say that the order, well, I think you say that the order has been complied with, but in any event, you need a substantial further period in which to provide further information. And although you say there has been non-disclosure and so forth, you're not in a position to proceed in relation to that matter today. Have I correctly understood the position of the parties?
Your Honour, I think it's slightly misleading as to whether the affidavit of Mr. Jummer is slightly misleading in the sense that he says that he requires 4 weeks to comply with the order. Is that what is not clear is whether that is generally or just in relation to the provision of information. I'm going to
ask Mr. Whitehead some questions in a minute. I just wanted to check that I've understood where the battlegrounds are in general terms.
Yes, your understanding is correct.
Your Honour, I think that's right, but I do think there's some slightly more nuanced arguments which we would like to make as well, based on recent events. Your Honour is probably not aware that a further affidavit was filed at 10:56, I believe, this morning, with additional documents and evidence. And there's also an issue in terms of the full and frank disclosure point, which we'd like to make.
Well, yeah. I haven't seen anything which was filed at 10:56 this morning. I've caught up now to what was sent to me at 9:45 this morning, but I haven't got to things which were only filed just over half an hour ago. When you say filed, that was sent to the court, was it?
You are quite right. We were also again, this is just sort of come in the last 30 minutes or so. So we've just sort of began to review it, and I believe this was sent to the registry and to the.
Sorry, this affidavit, this new affidavit is from the claimant, is it?
It is, yes. Correct.
Can I just clarify, Your Honour, that affidavit is in support of the applicant's position on a return date hearing, which I suspect is not going to be today. It's not for today. You don't need to concern yourself with it today.
Right. Okay. Well, I want to just clarify some positions as to this. First of all, I want to start with you, Mr. Whitehead. Is it your position that the affidavit which has been filed by your client complies with the order that has been made by me on an ex-parte basis earlier this week?
So our position on that is that the applicant, the respondent, has done his utmost within the time period allotted, which is a 48-hour time frame, to provide as much information as he can to try and comply with the order. That being said, as per his affidavit, he believes that he requires more time to ensure that compliance is fully adhered to.
Well, with respect, that's not a straight answer. I mean, if his position is that he's complied with the order, that's one thing. If his position is that he hasn't complied with the order, but it isn't practically possible to comply with the order, that's different. But which of those two is it?
It is. He requires more time, as per his affidavit, to ensure full compliance.
So the answer is that's the second form, and in order to ensure full compliance, he needs, he says, further time. That's right, is it?
Correct.
Right.
And I can give you reasons.
Well, no. I'm just trying to understand the position at the moment.
Yeah.
It seems to me that what that means is that what he ought to be doing is issuing an application to either set aside or vary the order which has already been made, And if the application is successful, then no doubt either further time will be granted, or if it's not successful, he's going to be at risk in relation potentially to an application by the claimant for contempt. Now, is he proposing to issue an application to set aside or vary the order which has already been made?
Correct, Your Honour.
He is.
Absolutely correct. Yeah, absolutely.
Right. We'll just pause that. So he is intending. When's he going to do that?
So my submission today was to suggest we try and regularize the position, and he needs some further time to do that. And in terms of
when's he going to? When do you say he's going to be in a position to issue that application?
So we would say it can be filed by the 25th of April.
Well, I mean, look, that seems to me to be an extraordinary period of time. If the application is to, I can see potentially that one might need some time, but if the application is simply to say, I can't provide full details of my assets within this period, I can't see at the moment how it can possibly take that amount of time to say that. It seems to me that that is within a very much shorter period.
Your Honour, there are instructions from the client. That being said, I take on board your points, absolutely. So we can look. The aim prior to this, just to make sure sort of we're all on the same page, there was the aim, as per the registry's email, was to try and regularise the position and agree a timetable with the claimant. However, it just was quite clear, and you probably have a chance to read the correspondence, that just wasn't going to be the case.
I'm the email from the registry was to try and resolve this by agreement. That hasn't been done.
Yes.
I'm now looking to see what practically ought to be done. My present view is as follows. Your client, as I understand it, says there hasn't been full and frank disclosure. Well, if he's going to say that, he's going to have to issue an application, and he's going to have to identify what the lack of full and frank disclosure was, and he's going to have to set that out. The claimant will then have to have an opportunity to respond, and if that's going to go ahead, we'll have to hear that substantively.
Yes.
Now, in relation to that issue, you will know, obviously, of the remarks that have been made that applications for full and frank disclosure shouldn't be made on a wing on a prayer, and so on and so forth. But that's one matter. The second matter is in relation to providing compliance. Now, the claimant has got a legitimate interest if it is otherwise entitled to the relief, both to the protection of the order and to compliance with the order that has been made. Now, it seems to me from what you've said that your practical position is you accept that there hasn't been compliance with the existing order, and you say the reason for that, as I understand it, is that your client couldn't have complied with the existing order within 48 hours. If that is right, if it's right that you couldn't reasonably have expected, then that would be the basis for extending time for compliance with the order. But you haven't filed the sort of information that one would need for that. One would imagine something along the lines of, I've got vast numbers of potential assets, together these all together, etc., etc. In other words, we aren't in a position even to deal with that at the moment. But that application, if it is made, has as its first stage seeking more time. Now, your client is frankly at risk in relation to this, because if more time isn't given, then the claimant potentially is going to be making an application for contempt against your client on the basis of failing to go forward. So where it seems to me to be at the moment is that in terms of matters, I'm very unlikely, in the absence of any applications, to make any order providing your client with additional relief today. What I might do is make a further order saying, right, any applications have to be made within a pretty short time period, and providing for a timetable for those to go forward. At the moment, it seems to me that those are necessarily going to be at the risk of your client. Now, that's how I see it at the moment, and I'm really inviting you to respond to that.
Thank you, Ron. Look, I think that's right. You know, certainly the purpose and what we've tried to do before this hearing and my submissions today were, as I've said, to try and regularise the position in circumstances where you know, we obviously look to adjourn the return date and issue directions to allow the respondent to file a formal application to discharge the interim order. Again, there's various factors, and I can go through those, but they've been rehearsed in correspondence before this.
Well, I understand that you say, I mean, just to be clear what you're talking about, I do understand that you say that various documents, I think you accept that you've got all of the documents which you would be entitled to now, but you say that various of them, for example, the skeleton argument and so forth, were provided late. I think that's your position, isn't it?
Your Honour, I think that's right, but I think I think we need to make you aware that it goes beyond that, certainly.
Okay, well, I'll give you an opportunity to do that in just a second. At the moment, I'm still setting the. So you say that there have been defaults in relation to the procedure which entitle you to additional time. That's what you're saying, is it?
So look, we're saying that given various circumstances, we need additional time to file, like you've said, to file an application to set aside the interim order. That's the first thing that needs to be done from our side, and we accept that. But there are various issues which we do need to draw to the court's attention, which have, again, just really come about after the last 30 minutes, given that a witness statement has just been filed, where documents have been put on the court record in the court hearing bundle, which we've only seen at the time of the court hearing.
Well, I mean, those documents, first of all, I haven't seen. If you're referring to documents which have been provided at 5 minutes to whatever the hour was, 9, I think. I haven't seen those documents, and I'm not going to take any account of them, subject to anything that Ms. Bijlani says today. So that's where we are.
I think that's right. Yeah.
Right.
You don't need to refer to them.
Well, just before we do that, I've said it several times, I'm going to give you an opportunity to just identify points that you want to make, and I will do that. I just want to hear from Ms. Bijlani just about the structure of this. Now, Ms. Bijlani, as I understand it, you're saying that there has been non-compliance, and as I understand it, Mr. Whitehead accepts there's been non-compliance, but the substance of what he's saying is that they did what they could within 48 hours, and inferentially, therefore, in due course, there ought to be relief granted in relation to that. Now, first of all, I don't think that that's an issue which I can deal with substantively today, for reasons which are fairly obvious. But do I understand you to be saying that is an issue which I can deal with today or not?
I accept, Your Honour, that there is no application before you, and so you can't really make a ruling in terms of any extension sought by the respondents. But just to be clear, in terms of, you know, the suggestion that the order has been complied with as quickly as possible, your order was issued on the 10th of March and it was read by Mr. Jummer on the 11th of March. A casual phone call was received by Mr. Whitehead by one of my colleagues on Friday, the 14th of March, asking for an extension, which I then sent an email in relation to and rejected in the absence of any proper details. On the 17th of March, we then received a letter from Mr. Whitehead.
I'm going to cut across you for these reasons. You, I think, are saying, and I understand you to be saying, two things. One is that I can't determine the issue as to whether there should be an extension, etc. today. Second, that there has been non-compliance, which I think is accepted in principle. And thirdly, for what you seem to be saying, is that it's obvious that what could be said, he hasn't done as much as he could have done. Well, just on that last point, just as he hasn't issued an application or just as the defendant hasn't issued an application in relation to compliance, neither of you issued an application for contempt. And so
that's correct, yes.
It doesn't seem to me that we're dealing with that. Just while we're on matters, are you presently intending to issue an application for contempt, or is your position on that, as it were, reserved depending on what happens?
I think the applicant's position is dependent on what happens imminently after this hearing. If we have compliance with the order, and the reason why we asked for direction 1 is because we want confirmation that no steps have been taken to dissipate assets in breach of this order since it was served. But if that affidavit is given, and we are given an affidavit in compliance with the order with full details of assets, then no application will be filed. But if this breach behaviour continues, then we will be filing an application for contempt and committal orders.
That's very good.
Can I just bring to your attention as well, just appreciate there are no applications before you, but the actual provision of information exhibited to Mr. Jimmer's statement is wholly inadequate. I mean, it simply says no assets.
Well, I've read it. I mean, I understand what your position is. Your position is that he identifies in very broad terms a limited number of assets, and said effectively that in relation to those assets, which appear to be very substantial sums, they're all wholly charged, and that it doesn't begin to deal with the detail of the matter. I mean, that's your position in a substance, isn't it?
It is, and Mr. Whitehead and his firm acted for Arj Holdings and Mr. Jimmer in the Bank of Singapore case, and would expect that they would know a bit more about his assets and what's been provided.
Well, okay. Sorry, just give me a second. Right. Now, Mr. Whitehead, I think what I'd better do now is to hear what you say in relation to what directions you presently seek. And if it isn't clear already, my necessarily provisional view is that the idea that a timetable which has anything like the 25th of April as being an appropriate date for this is, it seems to me, not realistic. And so this is your opportunity to identify what you say is appropriate, and also to identify any matters that you want to identify in relation to, in support of that.
Yeah, thank you, Your Honor. Your Honor, so I don't disagree with, I think your approach seems sensible in terms of, I think the main position, again, as I've said before, is to regularize the position so that each party has the opportunity to file the appropriate applications. And the main application we need to file, I accept, is an extension of time to vary the provision of information, which we intend to do. And certainly will do. There's various points I think you would like to make, and again, I appreciate, I don't want to waste too much of your time or the court's time on this, but I think certain points are important. The first one, again, we've only recently been instructed. Miss Bijlani's comment about us being instructed on the other cases is, I think, inappropriate in the circumstance. I don't think that should be brought before the court today. We've also got a situation where, as all the parties will appreciate, we're in Ramadan, and obviously getting client instructions is more difficult, and we need to produce information requested. So our client has every intention to comply with the order, but just needs the requisite time, which I think is not unreasonable in the circumstances. And again, what's happened recently, once we've got the case bundle, is that there's been additional documents, further documents which have been added, which raises a bit more of an issue in terms of this issue of full and frank disclosure. I take on board your honest comments about that and raising that application, but certainly we need time to consider that fully. I can draw your attention to the documents which demonstrate this if your honor wishes to, or we can do that at a later time. But there's approximately 6 documents, or maybe 7 documents provided in the case bundle from AS202 to AS203, which we've only just come to light in the last, like you say, 50 minutes or whatever, this morning.
So I mean, what are those documents, just in general terms?
So if we can take you on to those, so it's AS2, which is page.
I haven't got them. Can you just describe what they are?
Is it easier if I do them, given that we filed them? It's a second witness statement of.
Well, I think Miss Bellow's mentioned on it. I think that your honour's asking me to do
look,
that.
I really don't want. I did ask Mr. Whitehead. Just tell me what these documents are.
So we've again. So there's an email from Dr. Khan to EFG, re ARJ portfolio with Burgos Bank AG. So that's the first one. That's at AS2. There's a DVP transaction instructions at AS2.
So there are some detailed documents. How many pages in total of these documents are there?
Let's have a look. Approximately 20 to 25.
Right.
Something like
and
that.
You say that they raise detailed questions upon which you need to take instructions. Is that a fair summary of the position?
I think that's, yeah. I mean, look, obviously, we've only just got these within the last 30 minutes, so I've not had a chance to review them.
Well, okay, that's right. Now, in terms of, all right, I understand that you've got these documents and they raise questions. When do you say that you could file, first of all, an application to vary the existing order?
So I think we can do that very quickly. I think we can
by when?
I think we can do that within a week. So by 27th of March.
And I don't necessarily regard the 27th of March in the context of this as being very quickly. I was thinking, I mean, I would accept that you need the weekend, but I was thinking by the end of Monday.
I think we can. Yeah, I think we can do that. Yeah, right. We can do that.
Now, and that is simply an application to vary.
Yes.
In relation to an application to set aside for non-disclosure, first of all, are you intending to make such an application?
Yes.
Right. When are you going to be able to be in a position to file that?
So that's the one where we need some more time, which I think we'd need. I'd be grateful for till the 3rd of April.
Well, I'm not at the moment. I mean, first of all, are you in a position to identify at the moment what the grounds are of any application for extension of time?
For extension of time.
Sorry. Change that again. To set aside for non-disclosure.
Set aside. Yeah, it's mainly there's two points, but there might be more. But what the main one of the main points is full and frank disclosure, and again, there's also another point.
But if you're in a position to say that, you must at least be able to say what you say the application is for which is sorry, you must be able to say why there hasn't been full and frank disclosure.
I can do so in a very high level, but again, Your Honour, we've only literally just been provided with these documents. And Your Honour, there is one very important point I'd like to just raise here, if I may.
Right.
Is it in your transcript, and this is at page 446 in tab D2,
Yeah.
Your Honour has said, and I quote, "Well, I mean, look, one of the questions I was going to ask you, sorry to be bombarding you with questions, is that neither in your skeleton argument nor in the affidavit is there an express statement of matters which need to be drawn to the court's attention on the basis of a full and frank disclosure. And I was going to ask you, is there anything that should be brought to my attention before making an order?" Now, Your Honour, it's come to pass that there is information in terms of full and frank disclosure, which we feel needs to be brought to your attention.
Okay, right. Well, but I mean, that me saying you need to give full and frank disclosure doesn't get rid of that. I mean, there is or isn't. So if there wasn't, then you're in a position to identify it. Now, it seems to me from what you're saying that you are in a position to identify on broad grounds the heads of any disclosure quickly as well by the end of Monday. Is that right?
I think Your Honour, we said the extension request by Monday, but perhaps if we could have a slightly more time for identifying those points, given it's now Wednesday, we probably need a bit more time if we may on that point.
Now, okay. Now the third thing is that Ms. Pigilani is, in relation to this, and given the circumstances, asks that there be filed a further affidavit from your client confirming that there has been no dissipation of assets.
Yes.
Are you in a position to provide such an affidavit, well, straight away?
So Your Honour, on this, and this is a submission I wanted to make during the hearing, there's no positive obligation on our client to do so in the order. So Miss Vigilani's request.
No. She. I think. Well, I'll hear from her in a second. I think she would accept that. But what she's saying is that in circumstances where we're looking at the matter going forward, and you're effectively saying, well, I want to have time to do this and time to do that and time to do the other, then the provision of such an affidavit is appropriate. And what I'm asking is whether you're in a position to confirm that you'll provide such an affidavit. In one sense, one would expect that someone who says they've complied and has got no intention, there shouldn't be any difficulty about it.
Look, Your Honour, I accept that, but again, what's happened before today is that our client's been pressed into doing so.
I'm sorry, Mr. Whitehead. I think I'm asking a simple question. Are you in a position and willing to provide such an affidavit in short form or not? If you're not, that's fine. We'll proceed to consider it. But that's the question I'm asking you.
Yeah. Again, my instructions. I will need, if you can just give me a few minutes just to take instructions on that. I don't think our client has any objection to that.
That's what I'll certainly give you an opportunity. Right. Now, Ms. Pigilani, what I'm going to tell you now is on the basis of what Mr. White has said is what I propose to do in relation to this, and then I'll give you an opportunity to comment, and I'll give Mr. Whitehead an opportunity to comment. The first point is this: I don't think I am in a position substantively today to determine anything. I am, however, in a position to indicate that at the moment it looks to me that very unlikely that there has in fact been compliance with the order in terms of disclosure of assets. And I understand that effectively to be accepted by Mr. Whitehead, although what he says, it's perfectly plain, is that the client, his client, has done what he could. Secondly, it is apparent that the defendant wishes to issue an application to vary the order and also an application to set aside the order. And it seems to me in relation to variance, he's in a position to go ahead, and I am proposing to issue a direction that any such application, together with the grounds in support, be provided by 5 p.m. on Monday, the 24th of March. I'm also proposing that he issue the application to set aside for non-disclosure and indicate in broad terms what the grounds of non-disclosure are and why he can't provide full material and when full material can be provided. I'm also proposing to say that in the circumstances, it seems to me that as a condition of this order, he should provide an affidavit in terms of your Order 1, confirming that there has been no dissipation of assets. And it seems to me that that needs to be done by this coming Friday, tomorrow, at 5 p.m. I'm then proposing to adjourn all other matters, including the return date, until one has seen what is filed on Monday, because it seems to me at that point I'm going to have to issue further directions, which I'm going to do having seen what it is that's filed. Now, what that would mean is that your client doesn't get any immediate steps out of today, other than that there will be an affidavit identifying that there's been no breach. It will, however, mean that we will know where this is going, and it seems to me that that is as much protection as realistically you are going to get from today's hearing. The cost of today will, of course, be costs in the case, and you will then have to think about what's going to happen to go forward. And I'm likely to deal with further directions in writing and then have a substantive hearing in relation to matters. If matters haven't been agreed, well, it probably won't be next week, but possibly the week after, or something along those lines, depending on what the scale it is. Now, Ms. Bijlani, do you have any reactions in relation to that?
Thank you, Your Honour. I think we're generally in agreement with the proposed way forward. I would just like to raise a few points, a couple of points really. One, in relation to the affidavit that you're proposing is sworn by Mr. Jummer by 5 o'clock tomorrow. The applicants would want that affidavit to confirm that there has been no breach and will be no breach. And the reason for that is because, of course, while the application to vary is being dealt with, the applicants still don't have the information that they should have been given.
Well, Mr. Bijlani, just on that, you already. I'm proposing that the existing order shall go on, so you will have the protection that if he does so, that the reason why the statement that has been done is that it seems to me you're entitled to know that, because otherwise it seems to me rather other orders ought to be made. But it seems to me that in terms of there will be none, you'll have the protection of the existing order in relation to that.
Yes, I suppose the difficulty is that we won't have any information, because as I understand
you're not, I'm afraid, going to get any further information, it seems to me, well, between now and at the earliest next week.
Yes, I think, Your Honour, all I would say is that the applicants wish to reserve their right to make an application for contempt of court.
Well, that's a given, if I may say so.
Thank you.
Now, Mr. Whitehead, do you want to take instructions briefly on my the proposed orders, and in particular the affidavit, or do you want to make any other observations?
No, Your Honour, I've got instructions now on the affidavit which Ms. Bijlani requests in terms of the contents which you suggested. I think Ms. Bijlani wanted. I'm not
going to say there will be no further breach. It's the what I'm suggesting is as at one of her suggested order.
Yeah, it's quite. So we've got instructions on that. Our clients confirmed that he is willing to submit an affidavit to that effect. Yeah.
Right. Now, you heard what I said, Mr. Bijlani, as to the proposed way forward. Do you have any observations in relation to that?
I think that's more reasonable, and I'm in agreement to that. Yeah.
Right. Okay. In that case, thank you. I will now. The court will provide a formal order, but can I just identify what will be in the order first? Upon the submissions being made and upon the court not having read the material which was provided at 5 minutes before the hearing started, and upon Mr. Whitehead indicating that his client wished to vary the order and set aside the order for non-compliance. And upon or the claimant contending that there has already been a breach of the order by failing to comply with its terms, and upon the defendant indicating that it is willing to provide an affidavit as set out in paragraph 1 of the claimant's proposed orders for today, the court will order as follows. First, that the defendant provide a further affidavit by 5 p.m. tomorrow, the 21st of March, in terms of condition 1 of the claimant's order. Second, that by 5 p.m. on the 24th of March of 2024, the defendant shall issue and serve an application, 1, seeking to vary the terms of the existing order, and 2, seeking to set aside the same for non-disclosure. 3, that the defendant shall set out in an accompanying affidavit full grounds of the basis of the application to vary the order, and as much detail as it is able to do as to the grounds for setting aside for non-disclosure, together with material as to when it will be able to provide further information about the application for non-disclosure. 4, that upon receipt of that, the court will consider what further directions to make. And 5, that the costs of today be in the case, be reserved. And 6, that in the meantime, the existing order continues. That will be the order that I make. I will indicate, in addition to you both orally, that the court fully understands that the claimant's position as to non-compliance and the appropriateness of a contempt order is reserved. Secondly, that plainly, from the point of view of the defendant, it is proceeding at risk, in the sense that the claimant's position is that there has already been a breach of the order, and plainly that the sooner that any breach is remedied, the better is likely the position so far as the court is concerned when it comes to consider matters. Those are the orders that I propose to make today. Well, I was going to say I look forward to seeing you further, but it seems to me that it is likely that I shall be seeing you further.
Your Honour, I think I should, because obviously, as you'll appreciate, Your Honour, I am on client instructions on this, and our position, just to be absolutely clear, is as per Mr. Juma's witness statement, where he has said that he's attempted to comply with the order. I don't think he said he's not complied, but certainly he needs more time to provide further information.
I don't think anything in the order has said that he accepts that he's in breach, and that, as I said earlier, and yeah. I'll review the formal order, but I accept that that's the position. Yeah. I accept that there's no acceptance as to breach in relation to that, and in due course, if necessary, that'll have to be considered.
Yeah, of course.
Very good. Well, an order will be set up and drawn to the parties, but I hope you understand the substance of what it is that's required.
Yeah,
thank you very much, Your Honour.
Anything else from the court?
No, thank you, Your Honour.
Thank you both very much indeed. Bye now.
Thank you.
Thank you, Your Honour.